Thanks for tuning in to leftcoastnews.net, news and information from the wacky, sometimes communist, liberal West Coast of the United States. For more, visit leftcoastnews.net. Well, the voters of the state of Washington have spoken and actually won for once on 3 bills, 3 of 6 that were voter-initiated bills that the Democrats reluctantly saw pass. This is I-2081, the bill on parental rights, I-2111, the ban on income tax, and I-2113, the reinstatement of police pursuits, because voters are sick and tired of criminals going free. And these Democrats need to get it through their heads. We're tired of this. I-2118. I-2081, the Parental Rights Bill. A new section is added to Chapter 28A 605 RCW to read as follows. The legislature finds that parents are the primary stakeholders in their children's upbringing. No kidding. Parental involvement is a significant factor in increasing student achievement, and access to student information encourages greater parental involvement. Parents and legal guardians of public school children younger than 18 years old have all of the following rights: to examine the textbooks, curriculum, and supplemental material used in their child's classroom. Oh, you know, that is burning the ass of some of these Democrats who want you to have no right to look at this stuff or review this stuff or to have a say-so in any of this stuff. To inspect their child's public school records in accordance with RCW 28A 605030 and to receive a copy of their child's records within 10 business days of submitting a written request, either electronically or on paper. Parents or legal guardians must not be required to appear in person for the purposes of requesting or validating a request for their child's public school records. No charge may be imposed on a parent or legal guardian to receive such records electronically. Any charges for a paper copy of such records must be reasonable and set forth in the official policies and procedures of the school district. Public school records include all of the following: academic records, including but not limited to test and assessment scores in accordance with the RCW, medical or health records, records of any mental health counseling, records of any vocational counseling, records of discipline, including expulsions and suspensions, records of attendance, including unexcused absences, records associated with a child's screening for learning challenges, exceptionalities, plans for an individualized education program, or plan adopted under Section 504 of the Rehabilitation Act of 1973, and any other student-specific files, documents, or other materials that are maintained by the public school. To receive prior notification when medical services are being offered to their child, except where emergency medical treatment is required. In cases where emergency medical treatment is required, the parent and legal guardian must be notified as soon as practicable after the treatment is rendered. To receive notification when any medical service or medications have been provided to their child that could result in any financial impact to the parents or legal guardian's health insurance payments or copays. To receive notification when the school has arranged directly or indirectly for medical treatment that results in follow-up care beyond normal school hours. Follow-up care includes monitoring the child for aches and pains, medications, medical devices such as crutches, and emotional care needed for the healing process. To receive immediate notification if a criminal action is deemed to have been committed against their child or by their child. To receive immediate notification if law enforcement personnel question their child, except in cases where the parent or legal guardian has been accused of abusing or neglecting the child. To receive immediate notification if their child is taken or removed from the public school campus without parental permission, including to stay at a youth shelter or host home as defined in RCW 7415.020. To receive assurance their child's public school will not discriminate against their child based upon the sincerely held religious beliefs of the child's family in accordance with Chapter 28A 642 RCW. To receive written notice when the option to opt their child out of any surveys, assignments, questionnaires, role-playing activities, recordings of their child, or other student engagements that include questions about any of the following: the child's sexual experiences or attractions, the child's family beliefs, morality, religion, or political affiliations, any mental health or psychological problems of the child or a family member, and all surveys, analysis, and evaluations subject to areas covered by the Protection of Pupil Rights Amendment of the Family, Educational Rights, and Privacy Act. To receive written notice and have the option to opt their child out of instruction on topics associated with sexual activity in accordance with RCW 28A. To receive from the public school the annual school calendar no later than 30 days prior to the beginning of the school year, and to be notified in writing as soon as feasible of any revisions to such calendar. Such calendar must be posted to the public school's website and must include, at a minimum, student attendance days and any event that requires parent or student attendance outside of normal school days or hours. To receive in writing each year or to view on the public school's website a comprehensive listing of any required fee and its purpose and use, and a description of how economic hardships may be addressed. To receive in writing each year or to view on the school's website a description of the school's required dress code or uniform established pursuant to RCW 28A. To be informed if their child's academic performance, including whether their child is provided a student learning plan under RCW 28A, is such that it could threaten the child's ability to be promoted to the next grade level, and to be offered an in-person meeting with the child's classroom teacher and principal to discuss any resources or strategies available to support and encourage the child's academic improvement. Notwithstanding anything to the contrary, a public school shall not be required to release any records or information regarding a student's medical or health records or mental health counseling records to a parent during the pendency of an investigation of child abuse or neglect conducted by any law enforcement agency of the Department of Children, Youth, and Families, where the parent is the target of the investigation unless the parent has obtained a court order. Wow. So, boom. Democrats, that pretty much shuts down a lot of this garbage they are trying to pull in the public school system here in Washington. They won't be able to do all this secret squirrel transgender crap with your kids. They won't be able to try to convince your kids they should be something other than what they were born as. They won't be able to do all this stuff behind your back anymore. It's about time. I hope the Democrats got that message, that the people in this state are overwhelmingly sick and tired of this woke garbage. I-2111, a ban on income tax. This is one of Jay Inslee's and Bob Ferguson's little pet projects. They wanted so badly to establish an income tax in this state and just tax us. Sales tax, income tax, all of it. This effectively should shut that down, although I'm sure they'll still find ways to enforce some type of income tax. They'll just get creative. But for now, I-2111, an act relating to establishing that neither the state nor any of its political subdivisions may charge any individual person a tax based on personal income, and adding a new chapter to Title I RCW. New section. Section 1. Neither the state nor any county, city, or other local jurisdiction in the state of Washington may tax any individual person on any form of personal income. For the purposes of this chapter, income has the same meaning as gross income in 26 U.S.C. Section 61. Section 2. Section 1 of this Act constitutes a new chapter in Title I RCW. Short and to the point. The people have spoken, Inslee, Ferguson. You're not going to get us on an income tax. Enough of the taxes in the state of Washington. And finally, my personal favorite, I-2113 reestablishes police pursuits. It allows law enforcement to arrest criminals who have broken the law and run. 2113, an act relating to restoring the authority of a peace officer to engage in a vehicular pursuit when there is reasonable suspicion a person has violated the law and the officer follows appropriate safety standards, and amending RCW 10-116-060. Section 1 of that RCW has been amended to read as follows. A peace officer may not engage in a vehicular pursuit unless A, there is reasonable suspicion, and all the garbage the Democrats added to make it only for a violent offense, a sex offense, a vehicular assault, or assault in the first, second, or third, or fourth degree is struck out. Now it's just if there is reasonable suspicion that this person has violated the law. The pursuit is necessary for the purpose of identifying or apprehending the person. The person poses, struck out, serious risk of harm. That's gone. Now it just says the person poses a threat to the safety of others, and the safety risks of failing to apprehend or identify the person are considered to be greater than the safety risks of the vehicular pursuit under the circumstances. And except as provided in D2 of this subsection, the pursuing officer notifies a supervising officer immediately upon initiating the vehicular pursuit. There is supervisory oversight of the pursuit, and the pursuing officer, in consultation with the supervising officer, considers alternatives to the vehicular pursuit, the justification for the vehicular pursuit, and other safety considerations, including but not limited to speed, weather, traffic, road conditions, and the known presence of minors in the vehicle. For those jurisdictions with fewer than 15 commissioned officers, if a supervisor is not on duty at the time, the pursuing officer requests the on-call supervisor be notified of the pursuit according to the agency's procedures, and the pursuing officer considers alternatives to the vehicular pursuit, the justification for the vehicular pursuit, and other safety considerations, including but not limited to speed, weather, traffic, road conditions, and other known presence of minors in the vehicle. In any vehicular pursuit under this section, the pursuing officer and the supervising officer, if applicable, shall comply with any agency procedures for designating the primary pursuit vehicle and determining the appropriate number of vehicles permitted to participate in the vehicular pursuit. The supervising officer, the pursuing officer, or dispatcher shall notify other law enforcement agencies or surrounding jurisdictions that may be impacted by the vehicular pursuit or called upon to assist with the vehicular pursuit, and the pursuing officer and the supervising officer, if applicable, shall comply with any agency procedures for coordinating operations with other jurisdictions, including available tribal police departments when applicable. Pursuing officer must be able to directly communicate with other officers engaging in the pursuit, the supervising officer if applicable, and the dispatch agency, such as being on a common radio channel or having other direct means of communication. As soon as practicable, after initiating a vehicular pursuit, the pursuing officer, supervising officer, if applicable, or responsible agency shall develop a plan to end the pursuit through the use of available pursuit intervention options, such as the use of the pursuit intervention technique, a pit maneuver, deployment of spike strips, or other tire deflation devices, or other department authorized pursuit intervention tactics. The pursuing officer must have completed an emergency vehicle operator's course, must have completed updated emergency vehicle operator training in the previous 2 years. These cops already do this, where applicable, and must be certified in at least one pursuit intervention option. Emergency vehicle operator training must include training on performing the risk assessment analysis described in subsection 1C of this section. A vehicle pursuit not meeting the requirements under this section must be terminated. A peace officer may not fire a weapon upon a moving vehicle unless necessary to protect against an imminent threat of serious physical harm resulting from the operator's or a passenger's use of a deadly weapon. For the purpose of this subsection, a vehicle is not considered a deadly weapon unless the operator is using the vehicle as a deadly weapon and no other reasonable means to avoid potential serious harm are immediately available to the officer. For the purposes of this section, vehicular pursuit means an attempt by a uniformed peace officer in a vehicle equipped with emergency lights and a siren to stop a moving vehicle where the operator of the moving vehicle appears to be aware that the officer is signaling the operator to stop. The vehicle and the operator of the moving vehicle appears to be willfully resisting or ignoring the officer's attempt to stop the vehicle by increasing vehicle speed, making evasive maneuvers, or operating the vehicle in a reckless manner that endangers the safety of the community or the officer. It is about time. This never should have happened in the first place. Do you know how many idiot, moron criminals got away over the last couple of years because of this stupid law? These idiot politicians that passed this trash legislation should be locked up. They should be held accountable for every crime that was a result of these people getting away over the last couple of years. There was a murderer in Puyallup that they could not pursue based on this law because there wasn't enough probable cause. These idiot politicians who have never worked a real job in their life except maybe being a dirtbag lawyer prior to becoming a dirtbag politician should not be making these decisions. We already know, based on all this legislation I've talked to you about over the last couple months, that they are more concerned about criminal rights than victim rights. They are more concerned about criminals being allowed to commit crimes than the community or community safety. It is obvious. Crime has gone through the roof over the last couple of years. I know firsthand. It's about time that we let these officers do what they need to do and lock these people up. Let them know that they're not going to go drive their car through a business and then take off and there's nothing the cops can do about it. That they're not going to go steal your car or your property or break into your house or do all these property crimes that the Democrats have decided don't matter. That, they don't care about the long-lasting impacts property crime can have on people and business, and how expensive that can be. No, because they need it more than you do. They've literally said that. Hopefully this is a step in the right direction of establishing some order, some law and order again in this state. The people have spoken overwhelmingly. We're tired of this. This is going to change. We're not going to stand for this garbage. These politicians need to be put in their place.
Officer in pursuit of suspect vehicle. Assistance has been requested.
Any unit available for backup? Dispatch 6 southbound.
Thanks for listening to Left Coast News. For more, visit leftcoastnews.net. Please subscribe, like, and share to your social media. We appreciate your support.